Hello, this is Dr. Jacqueline Ranishek, and this is DTP Leadership Group. This is Hot Topic Bold Talk, where Richard and I try to present cases to you so that you can have a much greater understanding of what's going on in the court system. Now, Richard has chosen a case that I think is extremely interesting because it's going to address the issues around immigration. And I think it's going to give you some ideas because I certainly did not understand all of the acts and the statutes and all the things that are really related to the immigration. So I was thankful. I did read it all, Richard, this time. I didn't read just your highlights. So I'm going to turn it over to you and have you start us just kind of in a general way. And then, of course, I have lots of questions and I know you have lots of comments. Okay?
Sure. Well, the particular case we're dealing with today is not a U.S. Supreme Court case. Instead, it is a recent case from the Fifth Circuit Court of Appeals, which is the federal court which has jurisdiction over the states of Louisiana, Mississippi, and Texas. And by recent, I mean a case that was decided about 2 months ago. The name of the case is Buenrostro-Mendez v. Bondi. I'll just call it Mendez, but this case concerns an illegal alien who was detained by the government and who sought a bond hearing and to be granted a bond to be released from custody. The particular case that the district court in this individual's circumstance, and there was another applicant or alien as well by the name of hold on just a second, by the name of Covarrubias, who also was in the same situation. So each of these individuals were detained by the government with the intention of deporting them. They filed a habeas corpus petition arguing that because they had been in the country and were not detained while trying to enter the country, that they were entitled to a bond hearing. In both of their circumstances, the district court said that yes, they were entitled to a bond hearing, granted them a bond, and they had been released from custody. The United States government, the second name in the case, Bondi, is Pam Bondi, our former Attorney General. The government chose to appeal the decisions of these two district courts to the Fifth Circuit Court of Appeals. And the particular case we're dealing with today deals with the construction of an immigration statute, but generally what we're discussing will be certain legal rules that involve the interpretation of all statutes, all laws that are out there, because quite often cases hinge upon what a particular law means, whether it is a criminal law, or in this case, a law concerning immigration, or a statute concerning private civil rights of action and the ability to collect damages. So generally, the discussion will touch upon statutory interpretation. Specifically, it will touch upon the rights of these two individuals and whether or not they were entitled to a bond hearing. And with that broad introduction, I will open it up and let you, as you always do, ask your questions, and hopefully I will understand this well enough and can explain this clearly enough that hopefully I will help some of the listeners out today.
Well, I have no doubt you will. I think one of the things that might be helpful, just as in a beginning stage, there is a way that this has been purposely sent to this specific court because it's so conservative. And I think at any point in our discussion, I would like for you to explain some of the dynamics that go on around it. So I don't care when you do that, but I think it would be something that would be important for the listeners to understand. I think one of the things that really bothers me is Bondi was using the term seeking admission as a way to justify eliminating the bonds that these two individuals received. So I don't understand the language of seeking admission versus some of the other things that I read in the case. So I really appreciate you defining and clearly showing us what that means, and also what happens when someone arrives in the U.S. and seeks entry, or is a foreign person already here because they've lived here for years. So I'm going to ask you to answer those questions for me. Thank you.
Sure. And ultimately, you've touched upon the key issue. While the opinion goes on for, I think, 43 pages, ultimately the entire discussion by both the two judges in the majority and the one judge on this panel who dissents from the decision involves the meaning of a two-word phrase, seeking admission. And the statute is part of the general statutes concerning immigrants and the ability of immigrants to obtain admission to the country and obtain the proper legal status in this country. One of the provisions in the same group of statutes concerns people being able to seek asylum when they are from certain countries where asylum might be appropriate. But there are two particular phrases in the statute. One is the phrase seeking admission, and the other one is the phrase applicant for admission. And the importance between and the distinction between the two is if you're an applicant for admission, you fall under another particular section of the immigration code which allows you to seek a bond. And what I mean by seek a bond is it goes back to basic criminal law. If someone has ever been arrested, say for disorderly conduct or any circumstance, you can typically have a bond set, and when you post that bond, you're released from jail and you're allowed to remain out of jail until you wait for your trial to take place. Well, it works the same way with certain subsets of immigrants. Some of them qualify for and can seek a bond. And once they're granted a bond, if they post that bond, they are then released from custody and are free to return to their homes or residences and to wait outside of detention until their hearing takes place. And that's ultimately what the whole dispute deals with. Is the two applicants were arguing that an immigrant seeking admission is different from an applicant for admission. And in particular, they were saying they were applicants for admission. They were not seeking admission.
Right.
And okay, what do those two terms mean? Because I'm talking about them in the abstract. Seeking admission, what these gentlemen were arguing to the courts, was someone showing up and trying to enter the country at a port of entry or outside of a port of entry. By port of entry, I mean someone landing at Intercontinental Airport here in Houston or JFK in New York and attempting to go through customs and enter the country, seeking admission, or someone showing up on one of the bridges crossing the Rio Grande and, in the same regard, attempting to enter our country through an immigration checkpoint. They're seeking admission at a port of entry. Seeking admission could also deal with people who aren't going through ports of entry. Someone who chooses to cross the river at an area where you do not have a bridge and an immigration checkpoint, or someone who chooses to scale or cut a hole in our wall that we've been building and to come into the country that way. Seeking admission doesn't just involve someone showing up at a port of entry or which is I deem to be an immigration checkpoint. It also deals with anyone attempting to enter the country. And the point of these two gentlemen was we were not seeking admission. If we were, we wouldn't be entitled to a bond. We are applicants for admission, which is entirely different. And it's different because we were picked up and detained on the street while in the country or in our residence while in the country. In the case of one of these gentlemen, he had been here for 23 years. In the case of another one of these gentlemen, he had been here for 16 years. And it's a point that the dissent makes in disagreeing with the majority's interpretation, where they point out that we're detaining people that have been law-abiding members or have been law-abiding while they have been in the country and who have, in some cases, children and even grandchildren who are citizens of the United States because they were born here, which is a separate argument that the Supreme Court is or will be taking up, that being birthright citizenship. But these two gentlemen argued that because they were applicants for admission, because they were detained while already in the country and were not seeking admission at the time they were detained, they were entitled to a bond. Now, the majority disagreed with them. What the majority said with regard to the statute was the majority said, well, seeking admission and applicant for admission are interchangeable. You've agreed and acknowledged that you are an applicant for admission. And because these two terms, as we read the statute, are the same, that means you were seeking admission as well. Now, the critical legal difference here is because the two-judge majority decides that these gentlemen were seeking admission, the two-judge majority then decides these two gentlemen were not entitled to a bond. Mm-hmm. Now, I disagree with the majority. I disagree with the majority strongly. I'm going to start telling you why, and at any point, please feel free to interrupt me, because when I get on a roll, I still don't talk very fast. My voice may get louder, but I don't talk very fast. Now, first off, again, we're talking about statutory construction and statutory interpretation. And one of the main issues when you're dealing with statutory interpretation is generally you use a word as it is commonly understood. You use the common meaning of a word if it's not defined by the statute. And that's where I would like to start. Because I'm talking about this in the abstract, I want to go ahead and put up the particular statute we're dealing with, and let me know if you can see it.
I can't see it yet. There we go. Good deal.
Okay. And in particular, what I have highlighted in a bright color here is 1225A. No, we're talking about a different subdivision of the statute, but the reason I've highlighted 1225A is because it reads, and everyone can read along with me, an alien present in the United States who has not been admitted or who arrives in the United States, whether or not at a designated port of arrival, and including an alien who is brought to the United States after having been interdicted in international or United States waters, shall be deemed for purposes of this chapter an applicant for admission. Now, why am I reading that particular subsection of the statute? It's because when a statute does this, it has defined the term applicant for admission. It concludes, shall be deemed for purposes of this chapter an applicant for admission. So we have a definition of that particular three-word phrase, applicant for admission. And as I pointed out, it talks about aliens who are present in the United States and are not admitted, which these two gentlemen were. It talks about aliens arriving in the United States, whether or not they're arrived through a designated port of arrival. And it even points out that this includes aliens who might be intercepted in international waters and brought to the United States. So we have a definition for applicant for admission. The particular statute, though, we're dealing with is this subsection, and that's B2A. You see here the brighter highlighting refers to an alien seeking admission. Now, I see these two phrases as being different. Why? First off, as I pointed out, this statute or this chapter of the statute has chosen to or has structured so that it defines applicant for admission. Mm-hmm. So we've got a term that has been defined by the statute as I read it. The second thing is with reference to seeking admission. Now, what the majority does is they take these words and they use them in the abstract, in their opinion. But what they don't do, one of the ways you determine what a word means in a statute, in addition to its general meaning, is you look at the surrounding language in the statute to determine what might the meaning of the word be. Let me use as an example the word stream. Well, if I choose to stream a movie, that means something different from looking at the trees that overhang a stream. One, of course, involves what our viewers might be doing right now on their computers. The other one actually involves a physical body of water. And you know what I'm referring to by using that word stream by examining it in the surrounding context, the sentence or paragraph in which it is used. This is a basic rule of English, construction and interpretation. This is the type of stuff we learned in, grade school or junior high, or if you went to a school as small as I did, maybe you were in high school before you finally figured it out. But these are things we learn, literally as children. And the reason I mention that is with regard to the particular statute or particular subsection of this chapter, when they refer to seeking admission, if you go to 2B, there's an exception. And the exception says it shall not apply to an alien who is a crewman or to an alien who is a stowaway. Now, last I checked, if I get intercepted by ICE while driving north on I-45 out of downtown Houston, or while driving south out of Dallas on I-35, I am not a crewman or a stowaway. I am someone in the country. So these particular exceptions to the statute would only apply to someone who is arriving on a boat or a plane coming into the country. Someone who is arriving at a port of entry, using that language from the definition for applicant for admission. The other thing is if you look at 2C, it says in the case of an alien described in subparagraph A, who is arriving on land, whether or not at a designated port of arrival, from a foreign territory contiguous to the United States. So again, the seeking admission, when you look at the surrounding language concerning this term, it's talking about people trying to come into the country. And with regards to B, there's an exception here where Okay, it doesn't apply if I am, say, the flight attendant on a plane, or if I am in the engine room of a ship coming into territorial waters. With regards to B, basically the point there is, okay, if I'm showing up at a port of arrival, say at a bridge, and the country deems that I'm not authorized to enter the United States, then what they do is they don't have to take me in custody and hold me without bond. They can simply turn me away and send me back to the country I'm trying to enter from, be it Canada or Mexico, since those would be the two particular foreign territories that are contiguous to the United States, meaning their borders touch ours. But the point I'm making here is within this subchapter of the statute, 2A, if you look at 2B and 2B, where they're carving out particular exceptions, they all concern people trying to get into the country, not someone who's already lived here for 16 or 23 years, as was the case with these two gentlemen. And in my opinion, the two-judge majority just completely ignores the surrounding circumstances of the statute. They completely ignore the fact that applicant for admission has been defined by the statute. What is something else that they ignore? Well, one of the things that has been talked about with regards to this case is that um, for the past 5 presidential administrations prior to um, Trump 47, this particular section of subchapter of the statute that I've still got up on the screen had been interpreted by the administration, by ICE, Immigration and Customs Enforcement, under prior presidential administrations, to view someone who was already in the country as an applicant for admission, but not an alien seeking admission. And so you've got, what are we talking about? You've got almost 30 years of prior history where someone like these two gentlemen, who was taken off the street after being in the country for a substantial period of time, would have been entitled to a bond because this particular subchapter did not apply to them. I think that's important too. Um,
Richard, I want to interrupt you here for a moment because I think
sure.
we're going to talk about the dissent in a moment, and I think the dissent really clarifies how ridiculous the two judges interpreted the statute and focused on this, on particular A, ignoring B, and then even I don't think paid much attention to C in this situation. What I am really concerned about is you pointed out to me that there are 350 other cases for immigrants who were already in the country and were eligible to release a bond, but you're not hearing any of that in the way that the court is this court is deciding how to define something. So to me, one of the things that I see, and I'll just mention this, and then we'll go on with the legal aspects of it, but it is disturbing to me that when judges have been appointed by Trump, they always seem to find a way to support what he wants them to do, but they don't stick with the statute itself. Now, I'm going to put that out there, and I'm not asking for, anything except to acknowledge that. Because to me, it's very clear. The one you read in red says what an applicant is for admission. Now, I don't care if you've been here 23 years or you've been here 16 years. If you've been here, you haven't been a criminal. You've been a law-abiding citizen that has contributed to our community. How in the world did the two judges ignore applicant for admission? It's like they just left it out. So I don't know how, I want to know, please explain this to me.
Yes, and first off, you mentioned that I mentioned to you that there were 350 decisions that had found that individuals in the circumstance of these two gentlemen were not seeking admission, using that phrase.
Right.
And the specific source from that for that is actually from page 6 of the majority opinion. They acknowledge that there have been 300, they acknowledge by citing a case that listed the 350 prior decisions, finding that gentlemen in these, or not gentlemen, finding that persons in the circumstances of these two gentlemen were entitled to a bond. So the majority does, acknowledge that to be the case, but then kind of completely disregards whatever the effect might be of that. And the the manner in which prior administrations have interpreted the law to me is important. Um, and the reason it's important is because, you know, a great part of this experiment in democracy that our country has undertaken over the past 250 years is that we will have laws, and those laws will be interpreted consistently. The whole idea is, you know, in contrast to the monarchies that existed in the 16th and 17th centuries, um, in the 18th century, when we finally sought our independence from one of those existing monarchies, allowed for decisions to largely be made at the whim of the monarch based on whatever they felt like doing that day.
Right.
And a strong part of democracy is that the statute will be interpreted the same each and every time. And this particular statute, some some version of it has been in existence for quite some time, but the most recent amendments to the statute were in 1996. This means that in Clinton's second term, individuals like these two were viewed as not being aliens seeking admission because they had already been in the country for some time. Under both terms of George W. Bush, individuals in the position of these two were viewed not to be aliens seeking admission. During both terms of the Obama administration, individuals like these two were viewed by immigrations as applicants for admission, but not aliens seeking admission, so that they were entitled to a bond. And in Trump's first term, as the 45th president of the United States, individuals like these two were viewed to be applicants for admission, but not aliens seeking admission, and would have been entitled to a bond. Finally, when Biden was president, they were viewed the same way. It has only been during Trump's second term that suddenly the White House or immigration and customs enforcement has chosen to interpret this statute differently from the manner in which it had been interpreted for the past 29 or 30 years in an effort to try to detain persons that have been in the country for an extended period of time, and to do so without granting them a bond.
Right.
And it also troubles me that the majority doesn't pay heed to that you've got almost 30 years of prior consistent interpretation of this statute. And that and the 350 cases are important for a particular reason. I'm not going to go into all of the detail of the majority opinion, and their justifications for why they did what they did and how they did what they did. But a lot of the rules of law on which the two-judge majority relies are rules of law that apply when you have a statute that is not ambiguous, when it's not capable of more than one reasonable interpretation. And the problem with the majority's opinion, I say the problem, another problem with the majority's opinion is they just assume that there is only one reasonable interpretation of this statute. And to me, that assumption is betrayed by the language of the statute. It is betrayed by the decisions in 350 other cases before this two-judge majority decided to interpret it differently. And it was read in that manner over 29 years by 5 prior presidential administrations. And it seems to me that all of that evidence, because let's call it that, evidence, shows that the reading that these two applicants were presenting to the court was a reasonable reading of the statute, which would make the statute ambiguous, which would mean that the rules of the law that the majority relies upon, the crutch the majority uses to reach its decision, is not applicable to this case when you've got an ambiguous statute. Now, you touched upon it previously, and you kind of mentioned it in passing again, but what is it about this particular case that the Attorney General decided, okay, this is the one I'm going to take up to one of the circuit courts of appeal, one of the 12 appellate courts underneath the United States Supreme Court that decides issues of federal law? And the answer to that is that we're in the Fifth Circuit, we being Texas, where these two gentlemen were, where these decisions came from. And the Fifth Circuit, I think pretty much any lawyer you ask is going to acknowledge the Fifth Circuit is the most conservative of the 12 appellate courts in the U.S. court system. The Fifth Circuit is the court from which the Dobbs case came from, which that was out of Mississippi, but which was contrary to Roe v. Wade before the United States Supreme Court finally overruled Roe v. Wade. In fact, the Fifth Circuit has decided many issues before it where, to paraphrase what the Supreme Court has done, even with what people refer to as a 6-3 conservative majority, the Supreme Court has looked at the Fifth Circuit interpretations and has basically said, whoa, you're going too far here. So the Attorney General wanted this case in front of the Fifth Circuit because that was, in the practice of law, we refer to it forum shopping. They were picking a court where they had a better chance of getting the decision they wanted because judges are subjective. They're people just like you and I. So judges decide different issues in different ways. And they thought, okay, this is our best chance of getting a court to agree with us and follow this new interpretation after 30 years that we're trying to give to this statute. Now, how is it that they're able to do this? I think you and I may have discussed this previously. Maybe it was in private, maybe it was during one of our prior podcasts, but there was a decision by the United States Supreme Court that dealt with, of all things, immigration cases, where the court said, when you've got a single applicant, you can't issue a nationwide injunction or a ruling that will have a national effect. The rulings you issue will only have effect on the applicants you're dealing with. And what that has resulted in is, despite the fact that there were 350 other decisions that said someone living in this country is not seeking admission, they're already here. And as a result, they're entitled to a bond. Those 350 other decisions did not control what happened in this case. In this case, the Fifth Circuit was able to make its own decision and adopt the reading of the statute that the Attorney General presented to it. And what is the effect of that? Well, now with the Fifth Circuit making this decision, at least in Mississippi and Louisiana and Texas, you have what's referred to as binding precedent. The next time somebody comes into a court in Baton Rouge, Louisiana, or Jackson, Mississippi, or Austin, Texas, and they've filed a habeas corpus petition saying, I've lived in this country for a decade, I'm entitled to a bond, that district court now has to say, no, you're not. According to the Fifth Circuit, you are an alien seeking admission and you're not entitled to a bond because you fall under this particular subchapter of the statute. I do not practice immigration law, but I have talked to one immigration lawyer who mentioned to me that in discussing what's been happening with other immigration attorneys, that there is subjectively a belief amongst immigration lawyers in Texas that what the administration has been doing, in particular since the Mendez opinion was handed down, is when they're taking immigrants into custody that have lived in our country for a year or 10 years or 20 years, if they're doing it in California or in some other jurisdiction where they think this person might be able to get out on a bond, they are taking those immigrants and are literally sending them to detention centers in Texas and Louisiana. And the effect of that, or the believed effect of that, is twofold. One is you're isolating them from their support structure, people who could visit them and people who could hire lawyers to assist them. But two is you're trying to take an inordinately large number of people living in this country who have been detained, and you're now trying to put them in a jurisdiction, that being the Fifth Circuit, where the federal government will not have to release them on bond because this particular court has decided they're not entitled to be released on bond. Now,
and let me
yes, go
say
ahead.
something to you. I want to pause here and say I'm so grateful that you're going into the detail of this, because I think people in America they are not paying attention to what's going on in the court. So when something comes up like this, they don't have the data to say, wait a minute, there are 350 cases that these two people should have gotten the bond and they should have been released and given a chance to resolve whatever it is through an application. I think what bothers me about this, that our prior person, Bondi, I think she purposely chose the Fifth Circuit because she wanted to find a way to control the authority over any immigrant that she wants to deport or wants to have detained. She made that decision so she could please the president that she supported, which of course is Trump. I think that is the thing that disturbs me the most. The courts are supposed to be a place where we as Americans, whether we're legal or illegal in this country, however we got here, we have the right for due process and we have the right to consider what the history of our legal statute is. And it's not happening here. And I think, and I'm very glad that you pointed out the Mendez case, because it set up a situation where how many circuit courts do we have? How many did you say?
Well, you
12.
have
And you
11
got
regional circuit
one,
courts and then one for the District of Columbia.
well, you got one circuit court that is doing the total opposite of all what all the rest have, because Mendez has given them a chance to look at specific cases. So I think people need to understand that some of the decisions that are being made in the Supreme Court, you may not understand them until you see the connection with a circuit court decision like this one and say, oh, now I see what the game is. It's all about deporting, or it's all about detaining, and particularly, I hate like heck to live in Texas, and I know some of my friends in Louisiana and Mississippi hate what's going on here. But I have spent my life listening to how the Fifth Circuit has always been very conservative. So my question to you is, can you tell us some of the rationale that the dissent used? Because I think it's very pertinent. I think that it gives the rest of us an opportunity to say, no, that's what I want to happen with immigrants that live in the United States. And I want to see this so then we can make decisions about judges that don't support these ideas. So please give some information about the dissent, Richard.
Sure. And before jumping to the dissent,
Sure.
one more um, negative comment about the majority opinion. I find it problematic that they chose to metaphorically, um, or to use the analogy that um, applicants for admission to our country were the same as someone seeking admission to a college, applying for admission to a college.
Right.
But moving to the dissent,
Wait a
a
minute. I want
couple
to
of
go back to, wait a minute. I want you to go back to that, because when I read this case and I saw them applying it to someone applying for a college, I thought, this is ridiculous. The cases you're deciding about whether, not whether a person can go to a university or not, you're deciding whether a person has the right to have the freedom of life and liberty that we talk about all the time in our democracy. So please go there next, and then we'll go to the dissent.
well, I talked about it broadly and said I wouldn't go into specific examples, but since I went ahead and stepped in, threw myself into this briar patch, I will. Yeah, what the majority does is you're right, and I find it to be um, a really an inapplicable circumstance where they're again the statute defines applicant for admission, and what the majority does is they choose to analogize someone seeking admission or legal status in this country to someone seeking admission to a college, be it a local community college or an Ivy League college. It doesn't matter to me. It is an improper analogy.
Oh, I
And
know.
and as I said, they do this to really try and avoid the reality of the circumstance, which is that the language in the statute is ambiguous. It's capable of more than one reasonable interpretation. So they it's like three card Monty or a magician. They're created a distraction over here to hide you from all of the laws and rules concerning the interpretation of ambiguous statutes. It's I mean to me the fact that they had to resort to that shows just how lacking in support or substantiation the majority opinion is.
Right.
But in moving to the dissent, because that was what you asked me about, and I chose not to follow your prompt, um, I would start by pointing out that one of the things in the dissent that the judge says is normally when a judge dissents, the language they use is "I respectfully dissent." The particular judge in this case, Dana Douglas, who issued the dissenting opinion, um, does not respectfully dissent. Her opinion simply reads, "I dissent." Um, Typically, when a judge does that, it's because they have a certain level of displeasure at the opinion from which they are dissenting. Before saying that, she says, "Straining at a gnat, the majority swallows a camel." Um, that's not an analogy I'm familiar with, but as I understand it, it's similar to grabbing a tiger by the tail. You've really taken on something that is above and beyond your ability to handle it. And that's what the majority seems to have done in this particular case. Um, Now, what the dissent does, and it's one of the reasons I agree with it, is the dissent touches upon many of the things that you and I have already discussed. Um, the judge at one point on page 24 of the 43-page opinion, the dissenting judge says that in Mendez case, the court reasoned that as almost every district court to consider this issue has concluded, the statutory text, which we have discussed, the statute's history, which we have discussed, congressional intent, and Section 1226A's application to non-citizens already present in the United States for the past 3 decades support a finding that 1226 applies to these circumstances. And while we're talking about statute 1225 B2A, the importance of 1226 is that's the entitlement to a bond. So what the dissent is pointing out is you've got the text, you've got the history behind the statute, you've got the intent of Congress with the statute, and the statute's application by 350 other courts, and the past 5 administrations over 3 decades all support the applicant's readings of the statute and their arguments. And at this point, some people might be thinking, well, if they're illegal aliens, whether they show up at a bridge in Tijuana, or they are taken from an apartment in Chicago, what does it matter if they're illegal aliens? And with regards to congressional intent, there is an importance, there is a distinction to be made between someone trying to come into the country and someone like these two gentlemen who have been in the country for some time, who have, whether it is under a false social security number or otherwise, these are people who have been contributing to our economy, who have been law-abiding citizens, who very well may have children who are citizens of this country. And given those circumstances, the view of Congress is to treat people already in the country differently, to provide to them some privilege for being these types of individuals who have contributed in a gainful way to our economy. And to those of you who might be saying, well, they're criminals, you don't know for certain that they're the type of individual you're saying they are, I would say that likewise, Congress's intent betrays that counterargument. Because on the same page, page 24, the dissenting judge, Douglas, points out the Lake and Riley Act.
Right.
And for those who might not be familiar with it, Lake and Riley was the nursing student in Georgia who was murdered by an illegal alien who was in the country. And it turns out that individual had been previously arrested for certain crimes, some of them violent crimes, but had not been detained and removed from our country. And the Lake and Riley Act created another chapter of the same statute we're talking about that made it clear where you have an applicant for admission that those individuals can be detained without bond if they have committed certain crimes that are set out in the Lake and Riley Act. And what uh, uh, Judge Douglas does is she points out that if 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 1226 already allowed these individuals, any individual already in the country, to be held without bond, then the Lake and Riley Act would have been superfluous. The entire act and its passage would be unnecessary. No, the majority tries to counter this argument by saying, well, yeah, but the Lake and Riley Act also has certain provisions for parole. Well, the fact that it has certain provisions that do not apply to a bond doesn't mean that they would be rendering a large portion of the Lake and Riley Act useless or superfluous. Because in addition to those parole statutes, the Lake and Riley Act has particular provisions saying that individuals that have committed these crimes are not entitled to a bond, that once they are detained, you do not get to release them. And why put that in a law and have that law passed and have that law signed by President Trump if the statute already entitled you to hold an individual and to not grant them bond, whether or not they had committed those crimes?
Right.
You know, another point that's made by the dissent on page 25 of the opinion is she points out that the majority views alien seeking admission and applicant for admission to be interchangeable with no real difference. And she explains that this is not a credible reading of the statute and points out that consistent with the statutory definition of admission, the provision's context, the Supreme Court's understanding of the statutory scheme, and the whole history of immigration law view seeking admission to mean something that it sounds like, which is actively seeking to enter the country at the point in time you are detained. And that's another issue of language and interpretation that we haven't touched on yet. What the dissent points out is, are we talking about present tense or past tense in the language we're using? An alien seeking admission is present tense. And the reason it's present tense is because it's applying specifically to people attempting to come in to the country. So these are rules of construction that the dissent relies upon and that I consider to be a better reading of the statute. No, the other thing is on page 31, the dissent points out that the section that we're dealing with, or the chapter we're dealing with, 1225, refers to inspection by immigration officers. It refers to arriving aliens. That it deals with people attempting to come into the country. The language she uses, that section is replete with references to arrival and inspection upon trying to enter the country. That's different from 1226, the statute which permits a bond, which doesn't have any of that present tense language or the ability of the government to have immigration lawyers inspect the individuals or to take down information for individuals seeking admission. Again, it's statutory construction. And she concludes that seeking admission is not a throwaway phrase. It's not an extra phrase that means the same thing as an applicant for admission. It's a key term limiting the reach of 1225 B2A, which does not permit a bond, to a smaller subsection of of aliens or immigrants, and that is those arriving at the border and trying to get into the country. You know, the very things that we have been talking about during this discussion.
Right. And I think something that I appreciate that she does is she talks about the fact that the Congress does not secretly require, I'm on page 36 in the case. Congress does not secretly require 2 million non-citizens to be detained without bond when nothing like this has ever been done before, and the whole history of American immigration law suggests it would not be. We would expect more than simple statutory silence if and when Congress had intended a major departure. And to me, when I read the case, that said to me, there is something seriously wrong with this decision. Now, I don't know what the Supreme Court's going to do about it, but I certainly have grave concerns because they're going to have to me, they're going to have to separate out Mendez and say, wait a minute, we can't allow this. We've got one circuit court that is doing the total opposite of all the others. So,
Yeah, and three things here. One, I agree with you, and I agree with Douglas in the dissent. And her whole point is, look, if you're going to change a statute so that it has such an extraordinary effect economically on the government, I mean, think about the cost of building detention facilities to hold an additional 2 million people. Her point is, if they intended to do that, they would have said it more clearly. It wouldn't have been in language that 5 prior administrations had misinterpreted over 30 years until suddenly this administration, which had had a prior 4 years to get it right, suddenly figures out the real meaning of the statute. The other thing is you touched upon, and this really is kind of a good point to, I think, start to wrap things up.
right.
You've talked about the Supreme Court, and there are two things here. Is one, a lot of times the Supreme Court will take a decision because you've got different appellate courts, different circuit courts that have interpreted the statute in a different way. You have conflicting opinions. And I don't know that we're going to get that here. We may, because I think that the Attorney General's office had filed an appeal in another circuit that they thought also might be favorable to them, but I do not know whether or not they've abandoned that appeal now that they've got the decision they wanted, such that we won't have conflicting opinions. But nonetheless, this is an interpretation of a federal statute. This is an interpretation that will have a far-reaching and substantial economic effect. So I would think this is the type of decision where the Supreme Court, if one of the applicants seeks cert or applies to have that court hear the case, where the court very well might do so. In that regard, I would point out that one of the things that happened is just last week, the Fifth Circuit, the same panel that decided the case refused to grant rehearing. And after it did so, Douglas, the dissenting judge, did not request a vote for a rehearing en banc. What that would indicate to me is the judge or judges that disagree with the majority of opinion do not think they have the votes in the Fifth Circuit to reverse the decision of the two judges that issued this majority opinion. If they had decided to hear the case en banc, what would happen is the case would be argued in front of all 17 active judges in the Fifth Circuit, and then they would make a decision which could take some period of time. So by not electing to vote for en banc, basically what the Fifth Circuit has done is the judges who presume themselves to be in the minority are not going to waste additional time. Essentially, they're green lighting the applicants to go ahead and file for review with the United States Supreme Court to get the case there faster. That's my belief behind what is happening there and why we're not going to have an en banc opinion from the Fifth Circuit or an en banc hearing. And I would say that my opinion on this is probably supported by the fact that on April 21st, in an en banc opinion, the Fifth Circuit decided to diverge from about 50 years of U.S. law and decide that a law requiring the Ten Commandments be displayed in every classroom in public schools in the state of Texas, the Fifth Circuit said that that law did not violate the Freedom of Religion Clause of the First Amendment of the Constitution, despite the fact that there is a case interpreting an almost identical statute from Kentucky years ago that said that the statute does violate the First Amendment to the Constitution concerning freedom of religion. So I think that illustrates that if it had been decided en banc, the decision would have been the same as what this two-judge majority decided. And I think that also illustrates just how conservative the Fifth Circuit is when it comes to these issues. And I expect what will happen is one or both of these applicants will ask the U.S. Supreme Court to hear the case. I think the U.S. Supreme Court will probably agree to hear the case. I think you'll be able to get 4 judges that'll say, yeah, let's take this issue up. And it wouldn't shock me if we have a 5-4 or 6-3 opinion that ultimately agrees with the dissent, because amongst the so-called conservative judges, I've mentioned before that Justice Gorsuch is truly a strict constructionist when it comes to statutory interpretation. So regardless of people's feelings about him, this is a guy that's going to go very granular and dig into the minutia of the statute. And I think when he does so, he's going to come to the same decision that the dissent did, and say that no, these two different terms should have different meanings when used in the same subchapter of the statute. And I think that probably being a pragmatist, Kavanaugh or maybe even Chief Justice Roberts would fall on that side as well. So for the time being, this is the controlling law in Texas. I believe it's wrong, but I'm not a judge, so what I believe won't get you a cup of coffee at Starbucks. Still, I think that the Supreme Court ultimately will take this issue up, and I believe if they do so, they will reverse this erroneous decision, in my opinion, issued by the Fifth Circuit.
Well, and I think one of the things that's so important for us to all realize, just because Gorsuch, I'm not pronouncing his name correctly, you can pronounce it for
Gorsuch.
me, but Gorsuch, just because Gorsuch is a Republican, that doesn't mean that he is going to do anything but do his duty as a judge and to go into the detail. And because he's a strict constructionist, which some people are concerned about when we use that terminology, it probably will lead to what you consider to be, and I consider to be, a much fairer decision for these two individuals. Richard, I'm extremely grateful for the research and all the detail that you've given us today. I want to encourage my readers to do something. Don't blank out when you're hearing some of Richard's things about what these statutes mean. If you will stay present and hear all the connections he has skillfully done to present this case to both you and me, then you're going to learn something about the law. And I think it's important for all of us to do it, because right now the courts are where we have some form of democracy. So I want to thank everybody for listening to the podcast today. And Richard, as always, I'm very grateful to have you as a friend, a colleague, and I have thoroughly enjoyed talking with you today. Thank you.
Thank you.